now in session.
Good morning. Thank you. You may be seated. We are here this morning in our case number CACV15-0211, Santori versus Martinez Russo. Each side will have 20 minutes for argument. Counsel for appellants will be responsible for reserving any time you'd like to wish for rebuttal. These proceedings are being audio and video recorded, so we would ask you to identify yourself and your client when you approach the podium. We've conferenced this matter. We've read the briefs. We hope we're familiar with the facts and the argument. But with that, we look forward to your argument. You may proceed.
Thank you, Ron. Tom Slack with Tracy Gromer on behalf of plaintiff appellant Tammy Santori. Your Honors, the legislature has deemed it fair and reasonable to put the same duties as an employer on a broker for the responsibilities of a real estate agent. The language is that an employing broker, like Martinez Russo, is responsible for the acts of the salespeople acting within the scope of their employment. The language is clear and unambiguous. It doesn't permit for any limitations that aren't addressed in the legislation itself, other than scope of employment, which is doing something that is within the course of that employee's job duties. It does not permit for an analysis to try and figure out from a judicial standpoint whether, under this Santiago analysis or any other type of analysis, there is responsibility or respondeat superior responsibility for a real estate agent. That answer has been given to us by the legislature.
Seems like the focus of the statutes, the regulations, are more on the transaction itself, on the documents, the paperwork that's necessary to effectuate a sale, as opposed to the mechanics of how a salesperson goes out and finds prospective clients.
Your Honor, in some sense you're correct. If you look at the beginning or Section A of Section R428-1103, Section A does talk about specific transactional and a variety of other elements that I would call responsibilities for controlling the duties of a real estate agent. If you look at the next section, it doesn't call for any such limitation. And finally, by the time we get to Section D, which is really the one we're talking about here, it has no limitation, and it doesn't dictate duties or responsibilities for training, for supervision. It talks about respondeat superior responsibility or liability for that relationship. And what all of these statutes and regulations do is define a relationship. They say that if you are a real estate broker, you are not permitted to change the nature of that relationship to avoid responsibilities. They're very clear in articulating the various things that a real estate broker is responsible for. And one of them is for any act or omission that occurs while that agent is working in the course of and scope of their employment. And those employment duties are broad. They don't just relate to transactional elements and financial elements. They do very significantly involve interacting with the public, not just in terms of those things, but also in terms of driving out on the roadways.
What are we to make of the fact that what the statutes have done with workers' compensation insurance? We do not treat agents as employees for purposes of workers' compensation. Why would we make that provision?
The statute has said here, and the legislature has said here, what the responsibilities are. I guess that's the end of the story. But more importantly, this is not, the plaintiff's position is neither controversial or novel. In fact, everybody who has looked at this, the Arizona Supreme Court, in the context of a workers' compensation environment, but in reference to a Colorado case that determined it on the basis of the relationship between the parties, the broker and the agent. That was the reason for the determination, and nothing in Arizona law is inconsistent with that. Similarly, all the California cases that are on all fours with this, with less restrictive for the broker language in their statute, it doesn't have a blanket assertion that from a respondeat superior standpoint, if the agent is within the scope of their employment, the broker is responsible.
Has this come up in any other states outside California?
I don't know the answer to that, to be honest with you. Nothing that has been cited by the appellee has suggested that in any environment like this where there are similar statutes, that the court has not made that same determination.
But even, say absent the statutory scheme, just a real estate agent gets in an accident. In my recollection, I don't recall specifically. It seems like there was a case out of Missouri that went the other way, but I haven't looked at the Missouri statutory scheme. But it seems like something that would have come up. But the best of your knowledge, it's just California.
It hasn't. California is the one that has addressed this substantially. The Missouri case you're referencing, and there's another case that was cited by appellee, neither of those address any type of legislation or statutory environment in which that they made that determination.
It seems, and I understand the prior case law, but it seems odd that the legislature specifically overruled the case to ensure that agents aren't covered by workers' comp. So that seems to indicate what the legislature thinks is the relationship between a broker and an agent.
Judge Howe, I don't know that we can conclude that. I don't know any of the background or basis for why the legislature made those changes. What I do know is that if they wanted to make changes in this environment, in the context of a tort case for a driving accident, they needed to say so. Rather than a blanket statement in the legislation that says that they are responsible for acts within the scope, they needed to say other than driving or other than something else that would take it out of that. And they haven't done that, and they haven't elected to, and they are deemed to know what the consequences are of their legislation. And there's California authority that's directly on point. Back to sort of this not being novel or remotely controversial, the Arizona Association of Realtors, which is, according to their website, the largest trade organization there to serve the purposes of realtors, has determined through their counsel and very talented lawyer, real estate lawyers, Michelle Lind, that you cannot contract around this obligation to be responsible for your agents in the course of their employment, in the scope of their employment. That they have a non-delegable duty, but more importantly, vicarious liability for those activities. And finally, the restatement of agency.
And is that in the context? I noticed and maybe this leads to the restatement. The restatement is talking about someone who's driving the client is in the car. And is that the position that you're saying
No,
that you were referring to?
No, they have a blanket assertion that in those articles that we cited and provided to the court, that the broker is responsible for the acts of their real estate agent in the course of employment, or scope of employment, I think is the actual language, and that is tort liability as well. And finally, in the restatement of agency, that's just one representation of that, but there's nothing different or remarkable about having a client who's injured in your vehicle versus driving to or from a showing by yourself in a vehicle. There's nothing from a tort standpoint and a duty standpoint that's different about that.
Well, what causes you to say that?
Because if I am driving my real estate client to a showing, I have an obligation to drive safely. And that's my duty. If my duty is breached and I cause an accident and my client within the car is injured, then I can be sued for that. I also have a duty when I don't have a client in the car to drive safely, and if I breach that duty and I injure a member of the general public, I still am responsible. It's the relationship between the agent and the broker that's of importance. And in that relationship...
And I understand that, but what you just described describes the relationship between either the client and the agent or a stranger and the agent. And it's really the whole issue here is upstream liability, fair?
Correct.
And so it would seem to me that to the extent reliance has any application, that the equation would be somewhat different. And that's why I struggle with the thought that they're identical.
There's no reliance. There may be some reliance on somebody getting into a vehicle that they're going to drive safely, but that's not the basis of the tort liability. The basis of the tort liability is a duty owed to drive safely, not a duty owed based on some reliance or contract claim.
And again, I understand that if you're talking about the person that's injured and the driver, but with respect to upstream liability, it seems to me that they might be a little different.
Let me see if I can explain at least what I understand about that, and I think that that the cases all support. And that is the broker has a responsibility for the torts of the agent, pure and simple, whether that tort is occasioned by driving a client somewhere, driving himself somewhere for a meeting, filling out papers or contracts or documents. It doesn't require any reliance of anybody anywhere. It's the relationship between those two entities and the statutory environment that provides that
so
sets
we
the
don't look
stage.
at all to the degree of control that the broker exercises over the agent's driver.
You don't. It would be relevant if we were looking at the Santiago factors, but two things are involved there. The legislature has skipped to the end of the story, and they've told us that the broker is responsible for acts in the scope of employment. If we need to determine scope of employment, in other words, if it's not something that we already know exists because there are admissions that driving to and from meetings and being in your car and going places is an activity required of real estate agents, that is scope of employment. If we're looking at the Santiago factors, which we don't have to do because that just gets us to a judicial determination of the end of the story that the legislature has already told us, then we might need that. But to answer your question with a statement, they do have that obligation to control because they have to set policies, standards that are without limitation and don't relate simply to transactional, financial, and those sorts of things. They don't reference defamation or misstatements or anything that the broker is also going to be responsible for if done in the scope of employment.
So your answer would be the same then, I take it, if the salesperson is going to a training meeting in another state, renting a car and just driving?
Yes and no. If they are in the scope at the time, then they are.
They're going to a training meeting in Louisiana, renting a car.
About the facts, I suppose.
Driving from the hotel to a conference center.
If that's for their employer and in the course and scope, then I would agree with you. If this same gentleman, for instance, just to answer your question with what I think the limitations may be, it's relationship-based. And if he's at home and he says to his wife, I'm going to go get a pack of smokes, and he drives in his car to 7-Eleven and gets a pack of cigarettes and comes back and gets in an accident, there's no course and scope liability because, in fairness, he's not. Has the same relationship to the broker, but he's not in the course and scope. Nothing else changes in this analysis. The legislature has said this is an important enough relationship where the broker has the responsibility. He can't act, that agent, without the broker approving it and authorizing it and hanging a shingle there and being responsible. And the legislature has said it's too important. You're on the hook and responsible when they're acting in the course and scope.
If I could ask a question about the restatement, what are we to make of illustration 7 that says P employs a salesman who agrees to give full time to the work but furnishes his own car, is paid by commission, and can call on those whom he pleases. It is inferred that the salesman is not P's servant.
You know, I would say to you that in that setting, it doesn't say, unless I'm mistaken, a real estate broker, and the same regulations don't apply. And again, our legislature has been very, very specific in parsing out where those obligations begin and end. If this is just your blanket, if I hire a plumber, if I hire an electrician, if I hire anybody that doesn't have a licensure that says that when I hire you, you're my responsibility, and I'm vicariously liable for your acts in the course of your employment, then you go to the Santiago factors, and we have to figure out under that setting, is that right or not right. But here we don't have to do that. The legislature has told us the end of the story.
And
Again,
you would agree that if we take away the statutory scheme regarding brokers and real estate agents, there's probably not the degree of control over the agent's driving that we would impose liability here for the person that he's working for ostensibly.
I would say this, that they made a very strong effort to write language in their agreement that says independent contractor, independent contractor, independent contractor. I believe if you read through that language and look at the relationship, I think there may be a fact question there under those Santiago factors as we've set out in our briefs. But the strongest indication of what that obligation is by far, as Your Honor says, is the statute and the legislation.
Under Throop, that's the traveling salesperson. There's no liability there.
Yes, Your Honor. This isn't even remotely close to Throop, who's working for two different companies, has no statutory obligation for a salesman, and is off doing something to benefit himself and one or both of the employers, but not through any obligation of theirs to monitor or control. With Your Honor's permission, I'd like to reserve the rest of my time. Thank you.
May it please the Court, I'm John Barnes with Jessica Kokel for Martinez-Russo. Ms. Santori is asking the Court to jettison a century of respondeat superior cases because the legislature referred to real estate brokers as an employing broker, but the verb to employ has also been used to describe the relationship between a principal and an independent contractor. We see that in Throop, and we see it in other cases. And Throop is the controlling case here. As in Throop, Martinez-Russo's control over its salesman was limited to the transaction. It didn't extend to the day-to-day physical conduct of that salesman, such as who, when, where, how.
In Throop, was it an exclusive working arrangement between the salesperson and one company? Or?
That is a difference in Throop. The salesman in that case worked for another company selling its products. But the point is that the company, F.E. Young, I think it was, didn't exercise any control over that salesman's day-to-day physical conduct, such as when or where he made sales calls. And the legislature didn't do anything to change that. It intended to safeguard consumers from shady or unqualified salesmen. And so the control that you see the legislature giving to brokers under those statutes is limited to the transaction. It doesn't extend to the day-to-day physical conduct.
And what's your best argument for us to read the statutes to limit it to the control over the transaction as opposed to other activities that are necessary to carry out a sale?
Well, it's...
Is there any language in particular that you can point to?
Well, to Judge Howe's question earlier, the workers' compensation statute specifically contemplates an agreement between a broker and real estate salesman where the salesman is treated not as an employee.
And counsel, I understand that. Obviously, we're not here on a workers' compensation claim. In the Arizona Administrative Code, and I'll just read it, an employing broker is responsible for the acts of all salespersons acting within the scope of their employment.
And within the scope of the employment, I think, is the key phrase there, because the legislature defined what that scope would be by specifying what conduct the broker has to oversee. For example, the broker he must review documents, retain documents, and things that go to the transaction, and things that might go to the salesman's honesty in doing the transaction and things like that. It doesn't go.
Is it your position, and I understand that, but is it your position that traveling to and from a potential home or listing is not within the scope of the employment?
That's correct, Judge. For example, in this case, when the prospective client didn't show up, at that point, Mr. Horkos was free to go anywhere and do anything he wanted to do. He didn't have to go home. He didn't have to go to the office. He was free to use his time however he wanted to, and any schedule he had for the day was entirely self-imposed.
What if he's on his way, though, to meet a client, and the client's actually there, and he gets in an accident on the way? Would that change your analysis?
No, I don't think so, because that trip is not under any employer control. The broker has no ability to influence that conduct or that physical conduct.
But so the distinction you're making is with respect to specific control as opposed to scope of employment? In other words, it's sort of hard for me to figure that a broker or an agent, sales agent, wouldn't need to travel to and from within the course of their employment.
That's a good distinction, Judge. Yes, I agree that the travel to and from there isn't within the course and scope, assuming there's a master-servant relationship. But in this case, with the broker and the salesman, there's no control to even establish that master-servant relationship.
Well, I suppose it depends on how finely you wish to slice it. I mean, there clearly is with respect to, are you going to meet a prospective client of the listing, right? You would not argue that that's not within the scope of their employment. Let me ask a better question. When the salesperson is showing a home that's been listed to a prospective client, let's say instead that the client in this, or the prospective client in this case, actually showed up, and so they take a tour through the property. Is that within the scope of their employment?
So just so I'm clear, just we're talking about course and scope and not the master servant indicia of control in that context.
No question. I'm reading from the regulation, acting within the scope of their employment.
Well, so putting aside the question whether there's a master-servant relationship, then I think showing a property to a prospective client would be within the course and scope of the salesman's
employment.
Goal.
But the salesman isn't required to physically show the house. Perhaps they can do it over the internet, and the broker isn't requiring the salesman to physically show the house. That's up to however the salesman wishes to do it. Correct?
That's right. To be physically present, there's nothing showing that's required. As like in the Throop case, there was something in the contract that said the salesman had to make in-person sales calls. We don't have that here.
So, but my point though is that the broker is just controlling the transaction. How the salesman shows a house is entirely up to him.
That's true. That's correct, Judge. So, in the Santiago case, for example, just to give a contrasting example, the newspaper told its delivery driver where to pick up the newspapers, where to take them after that, and when. So we don't have any of that control here. And California follows the same approach. The Gibson case tells us that salesmen are not servants in the absence of the indicia of control that we're talking about. And one last point
You don't make any distinction, though, given the statutory scheme for real estate brokers and agents. I'm not aware of a similar statutory regulatory scheme for newspaper companies and newspaper delivery persons. Does that change the analysis?
Well, that's true. There isn't a statutory scheme governing the newspaper case, but I don't think that doesn't matter because it really boils down to the question of control between the principal and agent.
Well, what if you just had, we'll take it outside the context of real estate brokers, is just someone who's employing a driver to deliver something and doesn't necessarily care when or the specific when it's delivered or what specific route is taken. In your view, would the company that employs the driver, and it's just clearly an employee, he's someone who's just there, his boss just says, I need you to deliver something to John Smith in Peoria. You can do it whenever you want, however you get there. Would there be liability on the part of the employer there?
Well, I mean, potentially, assuming there is the master-servant relationship, but I think it depends on the sort of totality of all those control factors, and so I realize it's not a very satisfying answer. I guess it's hard to say, Judge, based on that scenario. Well, what I will say is, so in this case, Mr. Russo testified that driving is a necessary part of the job. You have to drive to get to these properties, but in Englert, the Supreme Court tells us that not all necessary conduct is under employer control. So the court was very clear that even if it's necessary, you still have to meet the control test to impose liability.
Is what boils down to that Martinez Russo wants the house sold properly, but he doesn't really care how the salesman goes about doing that. That's entirely within the salesman's independent purview.
That is what it boils down to, Judge, as in the Throop case. Driving was necessary in that case because the salesman had to make in-person sales calls, but the court found no vicarious liability. So, I mean, I think you stated it exactly, Judge Howe.
Counsel, let me ask you, is it your position that the statutory and regulatory scheme is complied with or doesn't address this issue, or some third point? Because I hear your argument largely arguing what common law cases say, and fair enough. But as you heard from appellant, their argument is we never cut to common law because the answer is by statute and regulation. What's your response to that?
Well, first of all, there's no indication that the legislature's intent was to jettison all of that vicarious liability case law. In fact, this court's found that the intent of the legislature was simply to protect consumers from shady business practices, and that has nothing to do with when, where, or how a salesman travels to a property.
And does that require us to follow that judicial declaration of what the legislation was intending and set aside the legislation, or does that mean the legislation still applies, but we just need to have that in the back of our minds as we sort of work through it?
I think the legislation still applies, but in a more narrow context than what Ms. Santori is asking in this case, because there's no reference to a salesman's traveling or anything like that in the statutes or the regulations. The statutes and regulations should be limited to their purpose and the things that the oversight that they specifically require, such as document review and retention and things like that.
And so, and again, I don't mean to harp on a regulation, but when it talks about responsible for all the acts of the salespersons acting within the scope of their employment, Do I understand your position that effectively you're asking to say, well, scope of employment doesn't include certain things that are required to do this, like traveling?
Well, I think what you said is right, Judge. The scope of employment is subject to all kinds of case law that help courts interpret what that means. And interestingly, paragraph A, I think, of that regulation starts off by setting forth a lot of the things that a broker has to do, and they're all completely unrelated to the conduct at issue in this case. So I just don't think that regulation really has any application here.
And the way you get there is that driving's outside of the scope of the employment? Or is it that the policies of the regulatory scheme are stated and don't include driving, and therefore we should read that phrase very narrowly?
I think both are true, Judge.
Okay.
Unless the court has any more questions, I'll ask the court to affirm summary judgment.
Hang on 1 second. It seems like I had one, but is there anything? Do you make anything of the fact that the broker directs the agent to carry insurance? Doesn't that suggest that that's part of the agent's employment? Everybody understands that you're going to be driving as part of the scope of your employment?
Well, no, again, that's just another restatement of Arizona law. You have to have insurance to drive. So it'd be if he said you have to have a driver's license.
But why do they need to have that in the employment contract?
I don't think they had to have that in the employment contract. The contract also said that the salesman's responsible for his own travel expenses and anything incident to whatever he might be doing. Did that answer your question, Judge?
Yes, that's fine.
Okay. Thank you.
Thank you, Your Honors. This is, first and foremost, and Judge Howe, if I understood some of the questions you were asking, I want to make sure and address it. There is absolutely no requirement of control over the acts of a real estate agent or an employee. It's only the ability or the right to control. And the right to control is laid out right in the statute, and it requires it, and it goes through it in detail, and it includes much more than just these Section A targets, and it talks about in Section B and C the obligation to enforce and have in place policies, procedures, and methods. And those were in place, and they were not followed. But even if they weren't in place, the obligation is to create them and have them, and the employer absolutely can say, you know what, we want you to not use cell phones when you drive. We want you to use surface streets rather than freeways because it's safer. We want you to do any number of things, and the agent has to comply with it because of that relationship. And they have to supervise and make sure it happens, but if they choose not to do that and elect not to do that, that doesn't get them out of it. Quite the contrary. It just shows that they are on the hook and liable for it. The legislature, again, has made that determination of responsibility in the scope of employment, and it has not indicated any exclusions to that. We can't read one into there. That isn't permitted by judicial interpretation. If there is an exclusion there, then the legislature has to set it out. They can correct it if they made a mistake, but they can't. We can't make some assumption that maybe they intended something other than what they've said.
Is there a difference? I'm just free associating here. A law firm hires a paralegal. Is it within the scope of employment to drive to and from your law firm? We wouldn't, presumably, the law firm's not liable if the paralegal is driving home from work. Why is that difference when it's clearly there's an employee-employer relationship? That's the
straight going and coming rule, and nobody's suggesting in that setting that it doesn't apply. The going and coming rule means that you're done with your day or you haven't begun your day. This context is very different. The only things we know with certainty is that he went to a showing for a business purpose and was coming back to his home office, and that all of that was within the boundaries of what a real estate agent does routinely in their practice, and that's for the purpose of serving the broker. They can't act on their own. The only place that money goes if they're successful in making the sale is to the broker. The broker, in return, has certain obligations that the legislature has imposed on it, and that responsibility is to be responsible for the acts of the agent when they cause harm. And that harm can be any number of things that relate to the scope of employment. That's why it's so broad.
Under Throop, assume there was only one, the salesperson is only working for one employer. Would your analysis be any different?
It wouldn't, because Throop was not a real estate agent. Throop didn't have a broker. Throop is a pure and simple either an employee or independent contractor, and you have to look at the Santiago factors, no question. Here, we don't. We know the answer. I don't mean to harp on that, but we know what the end of the analysis is.
But
so
why would the legislature not care about, if we're talking about the context of tort liability for negligent driving, why would the legislature care more about real estate agents driving than they do about someone who's selling sporting goods or something else?
I guess the reason is, and I can't speak for the legislature, but my suggestion would be that when you have a licensed group of professionals that has certain responsibilities, especially in dealing with the public, you have, according to the Arizona Association of Realtors, at least 40,000 that are just in that organization alone. That's a huge number of people out there doing a huge number of things, and you would want the one at the top of the pyramid who's making the money off the deal to be responsible and make sure that people are protected, whether financially, whether physically, and from tort liability, as well as any of the other activities or problems that can come from that many people doing that much work. Thank you.
Thank you both for your arguments and for your briefing. We will take this matter under advisement and issue a decision in due course. And with that, we'll take a temporary recess, but we're not going to leave the bench. We'll let the other counsel approach.